Shalom, my name is Michael Decker and I'm a lawyer within the law offices of Cohen Decker Pex Brosh. Today I wanted to discuss the standard civil proceedings in Israel. There are special civil proceedings such as a quick order or an abbreviated legal procedure, but we'll discuss those at another time. Usually when a party has a dispute against another party, before going to court it is common to contact and address the other party with a letter, either personally or by a lawyer, and to basically stipulate in writing your claims and the specific legal relief you expect from the other party. If the parties aren't able to resolve their disputes on their own, then the party that has a dispute with the other party can become a plaintiff and submit a lawsuit against who would become the defendant. After the lawsuit is submitted, the defendant has a chance to submit a letter of defense, and the plaintiff then can submit a letter of response to the letter of defense. After the lawsuit, the letter of defense, and the response are all submitted, then the judge usually schedules a pre-trial hearing. In the pre-trial hearing and prior to the pre-trial hearing, the idea is that all the parties finalize all the preliminary proceedings, such as questionnaires, such as specific requests to review various documents. And the main legal logic in Israel is that each party will be exposed to all the evidence of the other party. After the judge reaches an understanding that all parties are exposed to the evidence that the other party has, then the judge will schedule a time and a date for the actual trial. In the actual trial, there is the phase for the plaintiff and the phase for the defendant. In the phase for the plaintiff will bring his witnesses and usually sign them all on statements and declarations. And each of the plaintiff's witness will then go through a cross-examination if the defendant wants to cross-examine the plaintiff's witnesses. And afterwards, the plaintiff will be able to re-examine his own witnesses. Then we reach the phase of the defense, and the defense can also present witnesses of his own, and the plaintiff then will have the opportunity to cross-examine the defendant's witnesses. After all the cross-examinations are finalized and the trial is finalized, then both parties are allowed to submit summaries. Summaries are usually submitted in writing. However, at times the judge also allows the parties to verbalize their summaries right after the trial. After the summaries are submitted, and the summaries are usually based on everything that was submitted up to this point, including all the evidence that were gathered before the pretrial and including all the cross-examinations as were basically stipulated in the transcriptions of the court, then the judge will render a decision, and the decision will be sent to the parties. Of course, each party, if he is not satisfied by this decision, is able to submit an appeal before a higher court. If you would like our assistance in any civil proceeding, you can obviously contact us at the law offices of Cohen Decker Pex Brosh.